going to turn it over to David Anber, who will be speaking about impaired and over 80 updates. We are all familiar with David from our listserv. He's always excellent about sharing his excellent work with the rest of us and helps us build our charter base. So without further ado, go ahead, David. Thank you.
Thank you, Karen, and good morning, everybody. I'm going to get started with a bit of a poll. So if I can just take a moment to share my screen here. All right. The first poll question that I want to put to everyone, get everyone a little bit awake this morning. Taylor, if you could put that up on the screen. Everyone can take a chance to respond to that, and then we'll go from there. Give it a moment there for everyone to answer, and Taylor, when you think it's ready. All right, so I'm not exactly sure how it is, but 80% said yes and 23% said no. I guess 103% of the participants answered here. So for those of you who don't know how to play, basically blackjack is a card game. You want to get as close to 21 without going over, and face cards are worth 10 and aces could be 1 or 11. You play against the casino, also known as the house. And unlike the player, the casino or the house takes cards or stops taking cards by a set of rules. And the goal is to beat the casino by getting a higher hand. So I'm going to share the next slide here. Bear with me one moment, please. So looking back at what I had on the screen before, we see that the house has a jack or a 10 showing, and the player has a 7 or an 8. And so the question that I want to ask next on the poll is, if you were playing in this hand, what would you do? And if Taylor, you could put that up on the screen. Give it a moment there to let everyone get their answers in. And Taylor, I think when you think it's ready, you could just put the results up on the screen. Okay, so it's a pretty even distribution. Well, not even distribution, but there's a number of people who chose both answers. So 70% of you would hit and take another card, and 30% of you would not take any more cards. And so I'll close the poll here and share with you some statistics. Now, if you hit on that hand, you have a 22% chance to win. If you stand, you have a 23% chance to win. So that might be some support for those of you who said you would not take another card and not risk busting, not risk losing. It's a safer option. However, if you were to hit, not only do you have a 22% chance to win, you have a 6% chance to tie. What that means is that in actuality, the best thing to do is to hit, even though that's the riskier option, and even though there's a good chance you're going to lose, that's what you should be doing. Now, I want to draw an analogy to running trials, impaired driving trials, and I want to draw an analogy to those cases that we get where it looks like we don't have a chance to win. The Crown has a pretty strong case, and there's not much to work with from the point of view of the defense. So I'm going to call this scenario the weak defense case scenario. Now, in a weak defense case scenario, you know, we've all been there, we've all done trials where even where we didn't think anything could happen at trial, witnesses say what witnesses say. There are certain things that happen that we didn't anticipate. And so even with the weakest of defense cases, you still have a chance to win a trial. So let's estimate that as being about a 10% chance of acquittal. In addition, there's always a tiny possibility, overbooked courtrooms or whatever the situation may be, that maybe you get offered a careless on the morning of the trial. So that's 15% chance of either getting a careless or an acquittal. Now, if you plead guilty, there is a 0% chance of you avoiding a criminal record for your client. And in this scenario, I'm assuming it's one of those first-time impaired driving situations. And so, like the hand of blackjack, even though the safer option in many cases, particularly where it's a weak case for the defense, might be to plead guilty, there's still an advantage to going to trial. And so today, I'm beginning my presentation by maybe asking all of you to make a bit of the Montebello equivalent of a New Year's resolution, is for the coming year, try and take more cases to trial. Even those cases that you think you might not have much of a chance at trial, there's often things that can be done. And the purpose of my presentation today is to show you how you can take what appears to be a weak hand or a weak chance of winning a trial, which nonetheless is still strategically in your client's interest to go to trial, but how to take that and how to maximize the odds of winning the matter at trial, or maybe getting the Crown to offer a Highway Traffic Act resolution. So I've written a paper, and there are 10 topics contained within the paper. For the purposes of time constraints today, I'm going to only be addressing 5 of the 10 topics, but certainly if there are any questions that any of you have, you can either put those in the chat. I understand that there is going to be a question and answer period at the end of my presentation. You can also ask me any questions by email if you'd like to ask those privately, and my email is at the end of the paper, and you probably already have it from the listserv. Before I jump into the topics in the presentation, I did want to go over a couple quick technical points with regards to the paper. I note that the CCLA sent out my paper yesterday twice. The first time they sent it out as the full paper, which included all of the authorities that were cited within it. And so it's actually a fairly large document. And there was also a second document, which was a book of cases that establish what I point out as a systemic breach or systemic breaches of the charter by Ottawa police officers. I asked that the paper be sent again as just the paper because the first 2 sets of materials were very large. If any of you are looking at the full paper, I just want to put that up on the screen for a moment. Just give me 1 second. So this is what the full paper would look like. It's 447 pages. I believe when you open the document, it does not automatically open to the bookmarks. So if anyone has this paper open, you should go to the left side of the screen or whatever you're using to view the PDF in, go to the bookmarks section and open it up. And you should be able to access the hyperlinks of all of the authorities that are referred to therein. And so if you're using the full paper, which is admittedly a very large file, that's something that you should be able to do. Otherwise, you can just follow along as I refer to the cases. So I'm going to start with the first topic that I'm going to address today, and that's the immediacy requirement of the roadside breath demand. Now, I've chosen to include this as one of the topics because it appears that this is an issue which I would say appears in the vast majority of my cases in Ontario and even in Quebec. Although if for those of you who practice in Quebec, Quebec has some bad case law. Kwanzaa is not really the law there if the delay is under 15 minutes. And that's a whole separate subject, which I'm not going to get into today. But overall, at least for Ontario cases, and particularly with the Ottawa Police continues to be bad at adhering to the immediacy requirement as it pertains to the ASD demand. And also sometimes as it pertains to administering the ASD test itself. I would estimate that in about 80% of my OPS cases, there is a delay sufficient enough, or in cases where there's an ASD used, a delay that's sufficient enough to warrant a charter challenge. And in many of those cases, I'm able to get findings of breach. And this is one of those breaches that's easy enough to sniff out in an investigative action and through cross-examination. And typically, when you look at it on paper, if the officer says, you know, he arrived at such and such a time, and you can surmise when he formed his suspicion, that period of time from the suspicion until the making of the demand, it can sometimes even get bigger. They never really get smaller. You can sort of limit it to at minimum what is contained within the disclosure materials, but through cross-examination, you often find that the officer did in fact form his suspicion at an earlier point in time. Now, in the paper, I've included a list of cases that were recent, but I also included the one case that I found that was helpful on this subject from the past year, and I'll put that just up on the screen for a moment. Where'd it go? So in the paper, again, I had a number of cases from the past 3 years, but the one from within the past year would be the Roth decision, and I've cited it a couple places in my paper. And in the realm of immediacy, we know that Kwanzaa laid out 5 factors. And so what I'm actually going to do is I'm going to focus on one particular aspect of the immediacy argument rather than just the argument in general. Kwanzaa did lay out 5 factors. And what's often difficult is they're not factors in the traditional sense that they're all sort of the same nature and they're all balanced somewhat equally. I know the first factor is, for example, just a contextual statement about how Parliament has to strike the balance between enforcing drinking and driving cases on one hand and protecting individual liberties on the other hand. That's just more of a statement of intent rather than being a true factor. And then it goes on to list 4 other factors, and one of them is often misused by the Crown. Because the Crown will often point to this issue of the 5th factor of an opportunity to consult with counsel. And that's what I'm going to be really talking about today on this subject. Now, the opportunity to consult counsel is what I like to refer to in submissions as a one-way street. It's not what the Crown often holds it out to be, that if, for example, there is no opportunity to consult counsel, the Crown argues that this is a factor which weighs in favor of a finding that the demand was made forthwith or immediately, as the new wording of the criminal code section applies. And that's not what Kwanzaa says if you read it in its totality. The opportunity to speak to counsel, if there's no opportunity to speak to counsel, that factor is simply neutral. It doesn't weigh in favor of the Crown. It's just a neutral factor that doesn't apply to the facts of your case. However, the opposite is not true, that if there is an opportunity to contact counsel, there necessarily is a breach of the forthwith or the immediacy requirement. And against this backdrop, I wanted to discuss the case of Menzies, which I'm going to put up on the screen in just a moment. Now, Menzies was a Superior Court decision of Justice Schreck. It was an appeal decision, and so it's binding on OCJ trial courts. And it dealt with a very specific and narrow question, is who bears the onus in establishing the presence or absence of an opportunity to consult counsel? And I think the hypothesis is that because a charter applicant or charter claimant is the applicant in a matter, you would think intuitively that they would bear the onus. However, when we're dealing with the immediacy requirement of a roadside breath seizure, which is a warrantless seizure, we're dealing with a situation where the Crown bears the onus once it's been established that the seizure has been made without a warrant. And so Justice Schreck wrestled with that in the case of Menzies, which is found in my materials. Now, Justice Schreck in Menzies essentially takes us through not only the presumptions related to warrantless seizures, but some of the presumptions related to the right to counsel as well. And it's important to understand that as it pertains to roadside drinking and driving investigations. We have to remember that Section 10B of the Charter guarantees that upon detention, not just upon arrest, but upon detention, a detainee is entitled to be informed of the right to counsel without delay. And so ordinarily, in any type of investigative detention scenario, the police have a duty to provide the informational component of the right to counsel immediately. Not after a reasonable amount of time, not after certain steps are taken, but immediately. However, we know from the evolution of case law over the past decades that drinking and driving investigations have been carved out as an exception to the rule, where the right to counsel is suspended during the investigatory phase. And so even though normally a person under investigative detention, where there's only a suspicion on the part of police, normally they would be entitled to know of their right to counsel, and the police would be obligated to provide that right to counsel. In the case of alcohol-related driving investigations, that right is suspended until a later point where the police can form grounds to arrest or continue the investigation on some other aspect. And so because the right to counsel is suspended, this went up to the Supreme Court, and the Supreme Court determined that in cases like Thompson and in Woods, that the suspension of the right to counsel was a reasonable limit. So it did in fact violate the Charter, but it was justified under Section 1 of the Charter as being a reasonable limit. But it is only because of the immediacy requirement that applied then to the forthwith wording and now to the word immediately in the present wording. It is only because of the requirement of immediacy that the constitutional violation can still be justified under Section 1 of the Charter. And so Justice Schreck in the Menzies decision ties in issues about how a Section 1 onus is on the Crown. And so in cases where the Crown wishes to rely on that suspension, they bear the onus to establish that there was no opportunity to contact counsel. And I'm going to go just briefly to put that up on the screen. So in the Menzies decision at paragraphs 23 to 26 is where you get to a lot of the discussion about the onus. I mean, the whole case is a good read, and I urge all of you to take a look at it, and it's in my materials. But Justice Schreck goes to explain at paragraph 23 the rationale dealing with the Oakes test and who bears the onus there. And at paragraph 25 indicates that the analogy can be drawn to cases involving warrantless searches. And he says in paragraph 25, in other words, once an applicant demonstrates that there was a warrantless search, he or she has established a prima facie charter violation, and the onus shifts to the Crown to show that it was justified. The situation with an ASD demand is similar. Once the applicant has established that he or she was detained and not advised of the right to counsel, he or she has established a prima facie charter breach, and the onus shifts to the Crown to show that it was justified. And so bringing it back to the immediacy requirement as we normally frame it as a Section 8 breach, could also be framed and should also be framed as a Section 10B breach. And what you need to establish is that there was a detention. And so through your cross-examination questions, you should establish that there was a detention. It often starts in the form of either a traffic stop or a ride spot check. And then once it's been established that there's a detention and that no rights to counsel were given at the outset of that detention because it's argued by the Crown, or would have to be argued by the Crown to be brought within a valid suspension of the right to counsel. The Crown bears the onus to establish that that there was no opportunity to consult counsel, in the same way that they bear the onus to establish that the police otherwise acted immediately. And so I've included the case of D.C.A.O, which was sort of a three-part case that I've referred to in a number of places in my paper. I will come back to sort of how that case came about later on in this presentation. But the D.C.A.O decision, after being sent back from appeal to the original trial judge to complete her 24-2 analysis, the Crown was attempting to argue that the impact of the breach was not very significant because there was no opportunity to consult counsel. And Justice Dumel in that case pointed out astutely that the amount of time that there had been at the roadside where Mr. D.C.A.O's 10B rights were suspended was actually a greater period in time than the relatively short call he had made to counsel. And so the ultimate conclusion that I come to in my paper is that in any situation where the delay is more than just trivial, you should consider bringing the Section 8, but also the 10B claim within your charter application. Additionally, where there is a situation where the period of time that the accused spends speaking to counsel is shorter than the period of time that we're dealing at the roadside, that won't be determinative, of course, but it is certainly a factor that can be advanced or pointed to when arguing whether or not the Crown has met its onus to establish that there was no opportunity to speak to counsel. So I'm going to move on to the next topic within my paper, and that's the as soon as practicable requirement. Now, the as soon as practicable requirement, or the phrase as soon as practicable, used to, before the recent amendments to the criminal code, appear in three places, or at least three places of significance to us arguing breath sample cases. The first two places that they were found were in the section that authorizes the taking of breath samples at the station. That section refers to it one time in terms of the fact that it needs to be pursuant to a demand that is made as soon as practicable. And the second time in that same provision, it refers to the samples being given as soon as practicable, which have by all measures been interpreted to courts not only to mean the explicit requirement on the accused to provide the sample as soon as practicable, but that the samples be taken as soon as practicable. The third place that you found the phrasing of as soon as practicable pre-amendments was in the section 258 presumption of identity that basically related the breath results back to what the BAC would have been at the time of driving. And so the presumption basically said that where the samples are taken as soon as practicable, and there are other preconditions, you've got to be the first sample being taken within 2 hours, et cetera. But where the samples are taken as soon as practicable, that's a requirement. And if established, it results in the presumption of identity applying. Now, that's not a charter issue. Now, we know that the presumption of identity, the old presumption of identity, was removed as a result of the recent criminal code amendments. And as a result, as soon as practicable is not in play there. Now, the controversy that has arisen recently, and that is going to play out, I would submit, in the next year or so, we're going to see more and more cases that deal with this. The starting point for looking at this controversy is that there aren't many cases that deal with the as soon as practicable requirement as a charter issue. And there were practical reasons why this was the case. Because pre-amendment, the as soon as practicable was more often than not argued as a trial issue, not as a charter issue. And the practical reasons were threefold. Firstly, where possible, defense counsel often like to be able to lie in the weeds, not notify the Crown as to an argument that they may make. As a trial issue, the defense had the right to do that and to let the evidence shake out and see how the timeline was established or not by the Crown, and where it was not fully established or where there were multiple periods of unexplained delay or a single period of more significantly unexplained delay, the argument could be made that because of that, the as soon as practicable requirement was not met and the presumption didn't apply. The second practical reason why the defense would want to frame it as a trial issue is because, of course, rather than bearing the onus as a charter applicant to establish a breach on a balance of probabilities, as a trial issue which was determinative of an essential element of the case, the jurisprudence was pretty universal that the Crown had to meet this standard beyond a reasonable doubt. And so a second reason why that would be the preferred method pre-amendment was simply that it put a higher burden on the Crown. And the third reason, of course, is that if you treated it as a trial issue and the court was left with the doubt that the samples were taken as soon as practicable, that would end the matter, and the presumption of identity would not apply. You'd need not have to go to a second stage of addressing whether or not the interest of justice would be brought into disrepute under 24(2). And so those practical considerations meant that in the vast majority of cases where as soon as practicable was argued, they were argued as a trial issue as to the applicability of the presumption of identity. Now, there were cases, examples of cases where as soon as practicable was either argued as a charter issue as well, or where it was argued as a charter issue in the alternative to being argued as a trial issue. Usually the reason that this was done was because the Crown in a particular case was not seeking to rely on the presumption of identity. They were seeking to use a toxicologist readback, for example. So they did not need to avail themselves of the presumption of identity. And in that case, as soon as practicable would not help the defense unless framed as a charter question. There could also be other strategic situations where that could be the case, but that was the most common. So bearing all of this in mind, we get to what the controversy is right now. And the controversy comes from a case called Regina versus Moad, M-A-W-A-D. It's referred to in my paper. I don't believe I included the decision, but the citation is there if you want to look it up. That was a case that came from Milton, Ontario. And I found it interesting. I had an occasion to obtain the factums of the parties that had pled that appeal in Milton. And what had happened was the trial judge had found that the breath demand, not the samples, but the breath demand had not been made as soon as practicable. But the trial judge also made findings that the samples were not taken as soon as practicable. But when releasing her decision on 24-2, the trial judge really only focused the analysis on the fact that the breath demand was not made as soon as practicable. The trial judge performed an analysis under 24-2 and determined that despite the breach, the breath samples should be admitted. And so the matter went to appeal of conviction, and the main ground of appeal was that the trial judge had erred in her 24-2 analysis, and the Crown responded accordingly with a responding factum. Then months later, and this is the interesting thing, is months later, the Crown then corrects its factum with a supplemental factum that said something to the effect of, we originally agreed with the defense that as soon as practicable is a charter issue, but we now actually take the position that it's not. The as soon as practicable phrasing refers to the applicability of the presumption. That has nothing to do with the charter, and therefore it wouldn't have even been proper for the trial judge to have considered that on her 24-2 analysis. Now, Justice Andre of the Superior Court heard this appeal and essentially adopted what the Crown was saying. Now, the problem, of course, with the decision is that almost the entire focus of the debate, and you can see this in Justice Andre's decision, the entire focus of it was the use of that phrase in the provision that allowed for the use of the presumption of identity, Section 258 provision for the presumption of identity. And so Justice Andre quite rightly pointed out, said, hey, this doesn't actually confer any charter rights. This has nothing to do with the charter. And that is true. But for the most part, Justice Andre ignored and did not address the fact that there is also the provision in section, what it was then, section 254 sub 3, that subsists in the code now under, I believe it's section 250, pardon me, section 320 sub 20, 320.28, pardon me, where the wording has been maintained. Justice Andre didn't address that. And so I think the argument can clearly be made that that was wrongly decided. But since that case of Moad, many crowns in many jurisdictions, and most recently in Ottawa, have been bringing the Moad decision to court, standing for the proposition that it says that as soon as practicable is not a charter issue. And there have been a number of cases that go both ways on the issue. Now, there was another case from the Superior Court that was called Lee, L-I, and that's in my materials, that dealt with which dealt with a situation where the defense hadn't really properly argued as soon as practicable as a charter issue. And Justice Spies addresses that and says that, well, it arguably could have been a charter violation. And the reason that Justice Spies said that it arguably could have been a violation, notwithstanding the fact that it wasn't properly pleaded at court, is because, as we know, the requirements for a proper sample weren't taken, and for a warrantless seizure to be authorized by law, it needs to be authorized by law and conducted in a reasonable manner. And so to be authorized by law, it needs to respect the statutory provisions that set out the permission to take that warrantless seizure. And so Justice Spies mentioned that in passing. And so a number of cases have followed Moad and given effect to the Crown's argument. But the one case at the OCJ until recently, the one case in the OCJ that cited both Moad and Lee, considered the two lines of cases that have been developing over the last few years, and that case was called Araya, A-R-A-Y-A, and I've put those citations up on the screen. And so until recently, the only case that addressed both the Moad decision and also the Lee decision considered both of them, and considered both lines of cases that have been developing over the last few years. It is an OCJ case, but it considers both SCJ cases and the long lines of both cases on both sides, and concluded that as soon as practicable could be argued as a charter issue. But we now have a more recent decision on this, and I would submit a very thorough decision from Justice Duty on it, and it is somewhat, it leaves us somewhat pessimistic as to how we can use this as defense in the future. Justice Duty in his decision that I've included in the materials, it's called Regina and Pillar, P-I-L-L-A-R. In that particular decision, Justice Duty goes through the issue of as soon as practicable and rightly concludes that it is a requirement, and it is something that the Crown has to establish for statutory compliance in order to be able to justify what are presumptively unreasonable seizures of breath taken without a warrant. However, even though Justice Duty has no hesitation in concluding that Justice Andre wrongly decided the case, or at least that particular issue, Justice Duty nevertheless felt bound by the holding of Justice Andre in Moad. And now I've indicated in my paper a number of areas where I think Justice Duty's decision is vulnerable to attack if the issue comes up again. Certainly there are certain aspects of the argument that I would either emphasize more or present differently if I had this issue brought again. However, Justice Duty's analysis is very thorough, and before you address this issue in one of your trials, you certainly should take a read of it. You'll need to then bone up on the subject of per incurium, which is a subject that, quite frankly, I have not looked very much at, and I will have to look more at that before arguing this again. Two parting comments I will make before I move on to the next topic is, firstly, I would urge anybody who has this case to bring it, bring it to my attention certainly, but bring it to the attention of the DCAO. I think that this is certainly a topic where, or a subject where the DCAO should consider intervening should the matter arise again. It's of great importance to a number of cases. Essentially, the consequences of foreclosing as soon as practically being brought as a charter issue means that it serves no purpose anymore. There is no use for challenging the timeliness of the taking of the samples. I mean, certainly you might be able to argue it as a Section 9 detention issue. I note that I had argued that before Justice Duty in the sense of framing it that even if it were authorized by statute, it needs to be done in a reasonable manner. And I argued that by not taking samples in a reasonably prompt manner, that is not a reasonable manner, bearing in mind many of the authorities that refer to the purpose of the as soon as practicable requirement. Justice Duty's decision did not touch on that particular issue in Pillar. And so certainly this is an area of the argument that could be brought again, and certainly the DCAO might wish to intervene in such a case. The second last parting point I'll make is that if there is anybody who is attending today who is able to find a superior court decision, the first person at least that can do this, find a superior court decision that says that as soon as practicable is a charter issue or can be brought as a charter issue, I will personally give you a $100 gift card to any store or restaurant in the city. I think it's important that we find such a case. I've indicated why there's an absence of a lot of jurisprudence on the issue, but I certainly offer that challenge to anyone I don't have Westlaw, I use Quick Law mainly, but anyone who can find such a case, I issue that challenge to. Moving along to the next subject of my presentation today, that being the timing of the informational component on the right to counsel. I note that last year, the decision of Regina and Subaru had its 10th birthday. It's been 10 years now since the Supreme Court released the decision of Regina and Subaru, and still police forces across the province, particularly in the Peel region and also in the Ottawa region, but in many other areas and many other police forces as well, continue not to give what was clear language from the Supreme Court in Subaru, continue not to give it effect. Now, the Crown and Subaru, we can't forget, had argued for a flexible definition to what is meant by without delay. Section 10B of the Charter guarantees the right to counsel without delay. That includes both the implementational component, but also the informational component. And the Crown wanted a flexible definition to what without delay meant. And Justices McLaughlin and Sharon stated quite clearly that it was not a flexible definition, and it was not a definition that allowed for permissible forms of delay, but rather, to use their words, the right required, quote, a stable and predictable definition, end quote. And in coming to that conclusion, Justices Sharon and McLaughlin wrote for the Supreme Court indicating that without delay meant immediately. And yet we still find ourselves over a decade later, and this breach is committed at a very frequent basis by many police forces, again, particularly in Ottawa. Now I'm going to show you guys a video on the screens I was able to find. It's a police force, not in Canada, but it's a good illustration. I'm going to just play this for a moment.
Okay. What I'm going to do, I'm going to read you a couple of stuff, okay? At this point, you were not maintaining your lane while you were driving, okay? What I'm going to do, I'm going to do a series of exercises, and we're going to see if you are able to do these exercises, okay?
So what you've just seen there is a police officer, and there's a dash cam. And again, I say this each time the subject comes up. It's beyond me why we don't have dash cams in all of our police vehicles right now. So many things could be resolved easily with that, but that's a side point I'll mention in passing. But here we have a police officer who has an individual detained, what appears to be the equivalent, at least if this were a Canadian case, of on reasonable suspicion of impaired driving. And he's doing what's the equivalent of reading a demand for field sobriety tests. And take a look to see at what time we're at right now, just to get a context of how this investigation goes. It's currently 11:52 in the evening, 11:52 and a half in the evening. Move that along. 9 minutes of the field sobriety tests go by. And you'll notice that as he stumbles forward while performing that one-leg stand test, it's now 12 or just 1 minute past midnight, 12:01 in the morning. So only a little more than 9 minutes have gone by of the field sobriety tests. This is the conclusion of the field sobriety tests. And based on what we just saw, we're now going to see what is the equivalent of an officer forming reasonable grounds to believe that an offense has been committed. And this is where he places the individual under arrest. And it's important to look at what happens now that the field sobriety tests have finished. Take a look at the time again. It's 12:01 and 40 seconds. This is arguably the point where the officer forms his subjective grounds that an offense has been committed.
Okay, Mr. Dickman. All right, you can step out. You can step over by the front of my car. I'm going to do one more exercise. Okay? I'm going to read you something. Then we're going to go from there. Okay? You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to a lawyer for advice before you speak if you ask any questions, and if you have.
I'm actually going to cut it short here. It goes on for a little bit more, but you get the idea that he's reading the rights to counsel, at least the American version of the rights to counsel. And what ends up happening is after that's done, he then handcuffs and begins to search the individual after he's read the rights to counsel. It is incumbent on us as counsel to keep making this argument over and over again, that unless there are exceptions, and we'll get into that in a moment, and there's only a narrow range of what would constitute an exception, really what courts should expect from police officers is what we just saw there, is that when the officer tells an individual that he's under arrest, the sentence that begins with, "I'm placing you under arrest," or "you are under arrest," that sentence, before you get to the period, should end with, "It is my duty to inform you, you have the right to retain and instruct counsel without delay. You have the right to telephone any lawyer you wish. You have the right to free advice from a legal aid lawyer. If you're charged, you can apply for legal aid. 1-800-265-0451 is a number you can call. Do you understand? Do you wish to speak to a lawyer?" That should all be part of the same sentence in which an accused person is advised that he is under arrest. Now I'm looking at the time. I'm going to move forward a little bit faster, so I may have to gloss over a few points here, but it's all in my paper. Clearly, the Crown will raise two arguments, one of which really has no merit and one of which can be litigated more fulsomely. The one that the Crown will argue is in short delays. The Crown will say, well, it's only 5 minutes or it's only 4 minutes. It's no big deal. And that argument I point out in my paper for the reasons I've given today, it should have hold no water with courts. The real argument that the Crown can raise is, well, if the officer delayed the reading of the rights to counsel for legitimate officer safety concerns, that is a proper reason to delay. However, I would point out to the court that most of the time, I would say that the vast majority of the time when officers refer to officer safety, there really isn't a legitimate officer safety reason. They'll say things like, well, I've got to search him before I take him back to the cells. And that may be true. Okay, nobody is suggesting that he shouldn't search or she shouldn't search the detainee or cuff the detainee before bringing them back to cells. But the question is whether or not there is an officer safety concern that requires the reading of the rights, just like we saw in that video, whether or not it requires that to be delayed. Now, the decision of law from the Court of Appeal speaks about how generalized concerns for officer safety are not sufficient. And I've also included the decision of Gordon from 2018, which is a summary conviction appeal from Justice Hill, which dealt with an inherently dangerous dynamic drug takedown, as to use the word dynamic is what Judge Hill said, where the possibilities of surrender are uncertain. So in a dangerous drug takedown, Justice Hill was not prepared to find that the officer was required to read the right to counsel while the accused was seated behind the wheel of the car and told he was under arrest. But as soon as that accused was removed from the car and separated from the car where he would not be able to drive off, Justice Hill came to the conclusion that at that point in time, even in a dangerous drug arrest, the accused was entitled to be informed of his right to counsel. And so if in that type of case, Justice Hill, who was speaking as an appeal court to the OCJ, could find that there is not a valid officer safety concern there, certainly in many or even most of your cases, the prospects of there being an officer safety concern are even lower. And I've also included the decision of Al-Kaod. There were 3 decisions. There was the trial decision of Justice Dumel, where she acquits, the appeal decision where the appeal was allowed, the Crown appeal was allowed in part, and then the retrial decision, which went back to Justice Dumel to complete her 24-2 analysis. In Al-Kaod, there was a 6-minute delay of the right to counsel, or at least a 6-minute delay, and Justice Dumel found that the presence of another officer on the scene made it such that any claims of officer safety were not applicable in the circumstances of that case. The Crown appealed that as well, and that Crown argument was rejected on appeal. So we have some Superior Court jurisprudence locally that finds that that is a reasonable finding for a trial judge to make. Moving right along, because we're running out of time here, I go to the 24-2 analysis part. My paper essentially covers 3 subtopics. The first is the systemic nature of 10B breaches. The second is how we can legally distinguish the Jennings decision from your case. And the third is how we can factually distinguish Jennings. And so I'm going to briefly do an overview of those 3 things right now. In terms of the systemic nature of the 10B breaches, again, I've talked about how Subaru's been the law for 10 years now, and it is routinely a case, or routinely a breach that Ottawa police officers commit. We know that when performing the grant analysis, there are 3 branches, and the first line of inquiry is the seriousness of the breach. And a breach committed in an isolated sense may not be seen as seriously as a breach committed as a result of systemic failings or a systemic breach where many police officers are operating within a culture that allows the breach to occur. And this was something that was identified as being a problem in 2017 in the decisions of Simpson and Sandu, which are in my materials. They were decisions of Justice Schreck, as he then was in the OCJ. And while there aren't many cases that excluded breath samples solely on the basis of an untimely reading of the rights to counsel, Simpson and Sandu, there are a couple other local ones, but Simpson and Sandu are two of a very small group of those. And Simpson and Sandu were cases where Justice Schreck found that there was a systemic problem in the Peel region with police officers not knowing their responsibilities in regards to this right, this charter right. And so based on the systemic nature and the seriousness of the breach being so high, the long-term reputation of the administration of justice would be done a disservice by continually allowing breath samples to go in, notwithstanding that type of breach. And so Justice Schreck excluded the evidence. Now, again, that case dealt with and turned largely on issues of it being a systemic breach, and Justice Schreck cited between 16 and 18 cases in the area and by the Peel Region Police where that was a particular situation or a particular problem within the previous 7 years. Now, recently in 2020, and I've included this in your materials, probably the most important case on this subject is the Court of Appeal decision in Thompson. And that's in my materials, citations in my paper. Thompson concluded that it was a very serious breach for the exact same reason and spoke favorably of both Simpson and Sandu, and spoke favorably of the trial judge in Thompson, relying on the logic in Simpson and Sandu to find that the breach was so serious to justify the exclusion of evidence. Now, I was able to make this argument in the Pillar decision that I referenced earlier by Justice Duty, the one in which he performs a thorough analysis of the as soon as practicable requirement. And in that particular case, although Justice Duty did not entertain the as soon as practicable argument as a charter argument, and in the alternative, even if he had, he wouldn't have found a breach on the as soon as practicable requirement. His Honor did find a breach of the right to counsel delay for an 8-minute delay in reading the rights to counsel. And I put before Justice Duty, I believe it was 15 local cases from the past 3 years, and I've provided those in the materials to you, both a list of now it's up to, I believe it's 17 cases that I have found Ottawa police officers in the last 3 years having breached the 10B informational breach. I've included those here on the screen with 4 more from the past year. And Justice Duty was prepared to find that the breach was systemic. I set out in my paper why what argument you can expect to hear from the Crown regarding the systemic argument. They're going to attempt to treat this evidence as direct evidence, and as direct evidence, it would be flawed to rely upon, and I would tend to agree with that. However, this evidence is not being put forward to the court as direct evidence. It's being put forward as circumstantial evidence, and based on the number, it's strong circumstantial evidence. And this is a method of analysis, this inductive reasoning that is approved of in Thompson. It's done by Justice Duty, it's done by Justice Schreck, and it certainly could be done in one of your cases, be it with the rights to counsel, be it with the ASD immediacy breach, or even with a bunch of other breaches that the Ottawa Police commit. And so certainly this is information that you should put before the court. I do want to leave some time for questions at the end here. And so I'm going to abbreviate the last two aspects of the 24-2 analysis that I wanted to talk about. It's all in my paper, but essentially you should be able to distinguish Jennings either factually or legally when you're performing a 24-2 analysis. Legally, we're dealing with different baskets of rights if there are multiple charter breaches. For example, any breach that occurs at the stage of reasonable suspicion is temporally longer. The impact is temporally longer on the accused than a Jennings type breach, and might only be for a short period of time, but it is still temporally longer. But it is qualitatively different as well. The basket of interests is different. It's dealing with interests of a person who has not yet believed on reasonable grounds to have committed a crime. It's a basket of interests that include 10B rights that are being suspended. And so you should always find ways to distinguish your case from the very technical, solitary breach of Section 8 found in Jennings. And you should also be prepared to distinguish your case factually from Jennings. I note that Jennings, which had relied on the O. Young line of reasoning, which has been rejected, talking about being handcuffed, searched, taken to the station, kept in custody, put in a cell. All of those things spanned 106 minutes for Mr. Jennings, okay? And so that's what the Court of Appeal is referring to, saying, well, you can't consider those things because that would be true of all cases. So that's where you've got to calibrate at zero, the impact of those things. But where your case involves a lengthier detention, or where your case involves a person who has to use a toilet, even if you don't bring a mop, but use a toilet that's under video surveillance, or where a person is overheld, but you don't bring an overholding argument, but where there's some factual distinctions, and I've included some cases that have spoken about that as well, but where your case is factually distinct, you can argue that those things over and beyond what happened in Jennings are properly considerable under 24(2). The last thing I will ask, or the last thing I will have you guys take a look at today is the topic on resolution is dealing with a COVID careless. Many of you have noticed that the Crown is now offering COVID carelesses in addition to normal carelesses, where there's a legitimate, reasonable prospect of conviction issue, not one that totally deprives them of a reasonable prospect of conviction, but when there's an issue, they've often offered carelesses in the past. They're now offering carelesses on the public interest branch of the prosecution, where because of COVID and the backlog and the need to have trials conducted in a timely fashion, they're offering carelesses there. However, that usually comes with more strings attached, usually comes with interlock provisions and back on track and other things. So I would point out that there are also a number of areas where you are out of luck if your client wants a COVID careless. If any of these things here apply to your client, out of luck. I will say that, for example, where the accused BAC is more than 120 milligrams, I've had some success arguing with the Crown with additional mitigating materials, or with some triable issues, or with additional conditions being put into the probation order where it's outside of this range. I've had some success recently, and so certainly I encourage you all to open those lines of communication with the Crown, work together in terms of trying to find ways of resolving matters like these. And so I've done a quick summary of those last few topics. It's all in my paper, and certainly you can email me if you have any questions, but I wanted to leave some time to take some questions, and I'm just going to take a moment to read to see what, if anything, people have posted here. Okay, so the first question I got here is from Tumi Odele, and it asks me if I've been successful at getting evidence excluded based solely on breaches of 10B rights where no statement was provided by the accused. And I think I'll just build upon what I already said in the presentation, is that before Thompson, I mean, Pillar is certainly the first time I've personally been able to do that. But before Thompson, I have not had any success in the East region of getting that. And I think part of the argument I started making over and over again was that it brings the administration of justice into disrepute when we have a breach that's done so repeatedly, and courts just keep finding over and over again that because there's no impact or a minimal impact, that the police are going to get a free pass on that. That argument wouldn't really get much traction. There are two reported decisions I could send you if you emailed me where it was excluded on the basis of that alone in the East region. But I think that now, because we can establish it as a systemic breach, yes, the Crown will argue that there's no impact because the breach occurred and then nothing was collected in that interim period. But I think we have to remember that it's not just the actual prejudice, but the purpose of the 10B right and the immediacy is to protect against the risk of self-incrimination. So even though the police did not do anything or did not collect any evidence, the risk of self-incrimination is part of the interest that impacts the accused. Now, I appreciate it's not of the highest order, but it's not nothing either. And coupled with a serious consideration as a breach due to its systemic nature, I think we'll see more and more courts entertaining the idea of exclusion or even excluding. I also note that one counsel has indicated to me that in the past 7 days, he's done a full cross on 2 different police officers to confirm they've never been advised of any charter violation court decision. And we know that there's no system in place to do so. I'm sure Lawrence won't have any problem with me identifying that it's him who made that contribution. And Lawrence, you're correct. I can point out that the book of material, the second book of materials, in addition to my paper that I provided, which has a number of 10B informational breaches and a number of ASD immediacy breaches as well, those have all been provided to Chief Swally. He's acknowledged receiving them. I've since, after providing him that book, provided him the 2 most recent ones involving McGrath and Pillar. He has, at least it appears he received those, although he's not acknowledged receiving those. So certainly contact me if you'd like to get information or an affidavit to set out information that the police have been put on notice of these breaches. I note that in addition to those, I've also provided the rest of the breaches that the DCAO has collected over the last few years. I provided those to Chief Swally as well, and I could provide an affidavit of that as well. These are all factors which would increase the seriousness of the breach or a finding that there is a systemic problem with the Ottawa police. We have time for maybe 1 or 2 more questions if anybody wishes to submit those through the chat feature of the Zoom webinar. I'll just give a moment for anyone who wishes to put that through. There appears to be nothing. So, Karen, unless you'd like me to wait any longer to take on any more questions, I will wrap it up at that.
No, I think that's good. We did start a bit late. Thank you very much, David, for your excellent presentation and for the papers. And that's good to know that you're willing to do those affidavits. I'm going to pass it on to, yes, thank you. I'm just going to pass it on to Jake. Thanks again, David, and we'll see you later.
Thanks, Karen.
All right, thanks, David.